Hello, I'm Tom Cross. Join me for Cross-Examination, the podcast where I examine what the law has to say about the cultural, moral, or ethical issues of the day. In this podcast, expert panellists join me to take an independent look at the law surrounding one of these issues. Today, I examine the law's treatment of the issues posed by machine learning algorithms, used increasingly by the state and others to make decisions about our lives. The technology is still new and certainly controversial, to the point that some are calling for a moratorium. The use by the regulator Ofqual of an algorithm to calculate exam results for pupils during the pandemic led to protests outside the Department for Education using colourful language, and algorithms used by employers to work out who will be best at a job are begging as many questions as they're answering. Little wonder that the Equality and Human Rights Commission for England and Wales has identified discrimination in AI as one of its strategic priorities to investigate. So how does the law handle discriminatory or unfair results generated by these systems? And is the law suited to address the risks they pose, given the pace at which technology is developing and the specialism required to understand it? Cross-examining with me today are two colleagues at the bar and experts on the topic. Dee Masters is an equality barrister at Cloisters Chambers. She co-founded the AI Law Consultancy with Robin Allen KC in 2019. Since then, they've advised government, business, trade unions, and the UN on the equality implications of AI and related technologies. Jamie Susskind is a barrister at 11 KBW and author of two books at the intersection of tech, politics, and law, The Digital Republic and the award-winning bestseller Future Politics. Welcome to you both. Dee Masters, I suppose we'd better start by defining our terms. How does a machine learning algorithm get created?
A human coder will create an AI model and set it a task. The AI model will then be given a huge amount of data that will be relevant to that task. And then what the algorithm will do is it will look at that data and it will teach itself and recreate itself in order to learn how to achieve that particular task. So in the context of facial recognition technology that we're going to be talking about today, an AI model will have been told, learn what a human looks like. A vast database of faces will have been provided to the AI model, and it will then have looked at that data to learn correlations and relationships in the hope that going forward, it will be able to distinguish between different individuals.
All right, so what do we mean by machine learning algorithms?
I like to think about algorithms as being on a sliding scale. At one end, we have relatively straightforward algorithms that are often made by coders. They're used very frequently, for example, in the gig economy to decide which shifts people should be doing, what tasks they should be allocated. But then at the other end of the spectrum, we have these sophisticated machine learning algorithms. And what's fascinating about these algorithms is that they essentially self-create. So we have AI models that are teaching themselves how to make decisions in a way which outwardly, at least, appear to be akin to human decision-making. And it's when we're looking at those sorts of algorithms that we're really talking about artificial intelligence.
These are systems that maybe have been used in some sectors more than others. The financial services sector, I think, has used them for a long time in things like credit rating and so on. Jamie Susskind, are there particular areas or sectors where they're being increasingly used at the moment?
There are systems that are great at detecting patterns. So they churn through an enormous amount of data and they draw conclusions like, for instance, if a freckle looks a particular way, it's likely to be a melanoma. Then there are systems that learn how to do things. So self-driving cars, for instance, to the extent that they drive, is not because a driving instructor has sat down and taught them how. It's because they've processed enormous amounts of data about how cars have been driven in the past. And so they know that when the light turns green, the appropriate response is to move. And when it turns red, the appropriate response is to stop. And when you transpose that into the world that we live in, you can see that these algorithms are increasingly being put to use in a number of ways. You've got employment, an area of particular interest to me. So you've got algorithms that are being used to advertise jobs, to recruit people, to screen CVs, to interview them, to monitor them when they're at work. You've also got the police, you've got local government and others.
What about facial recognition technology? I mean, that could be something that's used both presumably by employers, potentially, and also by the state in terms of police.
So facial recognition technology is a brilliant example of a machine learning algorithm. They're certainly used by employers. They're used in two ways. They're used to identify people. So, for example, there's some litigation going on at the moment against Uber in respect of whether facial recognition technology is discriminatory in terms of identifying drivers. Is this the person who's supposed to be driving this car at this point in time? But they're also used in something called emotion recognition technology, which is where employers are frequently using AI to interview individuals and decide, is this my ideal employee? And perhaps more terrifyingly, this technology is being used to decide, who can I get rid of? Who should I dismiss? Who should I be making redundant?
And there must be a number of reasons why these are being increasingly used across society. I suppose there's more data that's been available to people to develop the software now because of the amount of data that we've all given bodies over the course of recent years. And the technology itself would be becoming more sophisticated. Do people think that it's advantageous to use these things with naivety? Or are they along the right lines, do you think?
You're absolutely right about the colossal and exponential growth in the amount of data that is being collected and stored in permanent or semi-permanent form. Crucially, that's also been twinned with a massive exponential growth in computing power, without which such machine learning systems would simply be impossible. And the question is a great one. Why is it that corporations and governments alike are turning to this technology to try to meet their goals? Now, obviously, they will feel that it serves their purposes. And particularly in a market economy, I think there is often a sense among businesses that if they're not using this technology, someone else will. Just to give an example I saw in my research not so long ago, it turns out that if you use a Hotmail email address, a machine learning system determines that you are more than twice as likely to be in a car accident. Don't ask why. It's the kind of bizarre correlation that these systems are great at finding that humans would never spot. If you're a car insurer and you don't use that information when deciding how and on what terms to give insurance, then you might be thinking your rivals will. And that might put you at a competitive disadvantage in the market. And you see that anxiety playing out in all kinds of different sectors.
One can see in theory the potential for technologies like this to be harnessed to help tackle problems of discrimination because it enables a source of where people are potentially being less favourably treated. It enables that data to be collected, as it were, and processed and then outputted into some useful tool. Is that proving too hopeful and objective?
I think it depends what sort of tool you're looking at. If you're looking at these really sophisticated machine learning algorithms that make judgments about people, are you going to be a good employee for me? Then there really isn't very much evidence so far that the decisions that are being made are better than human decision makers. And in fact, there are lots of downsides. But equally, I think there are some applications of this technology that could be really helpful. So, for example, we know there are tools out there which can remove data about gender, about age, about racial background from job applications and CVs. That's going to be very powerful in terms of pushing forward an equality agenda. There are tools out there which will allocate work within law firms so as to force male partners to work with more junior female colleagues rather than simply going to the younger solicitor who reminds them of themselves. So I think there's lots of scope for really positive advances, but I think it would be dangerous to think that AI is superior to humans in such a way that all discrimination can be eliminated.
All right, I want to focus on the legal problem and two areas: risk of discrimination, so breach of discrimination law, and separately the risk of unfair data processing. We start with risk of discrimination. Jamie Susskind, you mentioned before the issue of its use in employment, for example, to recruit. How might a concern about discrimination arise if an employer chooses to use one of these systems in their recruitment processes?
You've got this debate within the algorithm community about whether these systems actually give rise to a greater or a lesser risk of discrimination than your ordinary human being, warts and all. Here's how discrimination might arise. There was a system designed at Amazon, which was never actually put into use, but it was a recruitment system. And what this system was designed to do was to churn through the CVs of the people who were already at Amazon and detect via pattern recognition the characteristics of those CVs which correlated to being a successful employee. And then what would happen is that those characteristics would be applied to the CVs of people who applied to the company for jobs. So the theory is, let's find the characteristics of successful people here, and then let's use those to filter out job applicants. Here was the problem. Amazon had typically been a company that was dominated by men. There were far more men in senior positions than women. And so what the algorithm learned was that the strongest indicator of being successful at Amazon was being a man. That meant that if your CV contained the words women's volleyball team, or the name of an all-girls school, or an all-women's university, it went to the bottom of the pile. So Amazon set out with what sounds like a technically admirable mission and end up with something that does not reduce the discrimination that already exists in the world, it reproduces and amplifies it. And that's one of the great risks with machine learning technology. They can only do what they can with the data that they are given.
In a sense, you're only as good as your data.
Exactly. If you train a facial recognition system using a database of only white faces, that system is going to have a great deal of trouble recognizing non-white faces. Just like if you train a voice recognition system on people with a particular accent, it might struggle to hear the accents of people who speak differently.
Presumably the same problem applies in other contexts, in a state context. If you think about the police, for example, where you should investigate or target resources. The police thinks, well, it's a jolly good idea to have some kind of AI to help us with that. It's going to be cheaper for the public purse and so on. But if the historical data you've got to train that model that looks at where you've investigated people, who you've arrested, who you've charged, is itself biased, then that's going to feed into where you target your resources, and the risk of getting it wrong, targeting the wrong people, can equally arise.
Exactly, and computer scientists have a phrase for this: trash in, trash out. We need to move away from this idea that when you get discriminatory outcomes from algorithms, it's because of flaws in the designers. Often the flaws are in the data because the real world itself is biased. So if you train a large language model to solve word games, man is to doctor as woman is to, it will say nurse, not because the person who designed the algorithm was a misogynist, but because the data itself reflects an inbuilt bias.
Don't blame the AI, blame the data, Dee.
Absolutely. And sometimes what these AI models are doing is quite explicitly using data about people's protected characteristics, so their sex or their age, or proxies for protected characteristics like postcode, in order to make decisions. So if you're thinking about the police, we know that there are AI models out there which will recommend to custody officers what's the outcome that should be applied in a particular case. And we know these algorithms will look at sex. We know they'll look at age. So there's always the potential there for decisions to be made in a way that's directly discriminatory, namely treating someone less favourably because of one of those features.
So, Dee, just let's take a step back and have a look at the legal framework that operates here in terms of risk of discrimination specifically, first of all. So, anti-discrimination law. You mentioned the idea of protected characteristics. This is a concept in the Equality Act 2010. Just help us to understand how that act is set up, what the protected characteristics are, and what discrimination means in that legislation.
The Equality Act protects certain categories of people in respect of features like sex, race, age, disability, sexual orientation, and it prohibits different types of discrimination. So first of all, you can't treat someone less favourably because of a protected characteristic. So Jamie's example with Amazon is a really great example of direct discrimination, a different standard being applied to women versus men. Then we have indirect discrimination, which is where an AI model appears to be neutral, it appears to be doing something useful, but the outcomes of the system place a disadvantage on certain groups. And then we also have, and it's really important to talk about this in the context of discrimination in AI, special protections for disabled people. Because the way that a lot of these AI machine learning models work is that they essentially create stereotypes. So what typically does an ideal employee look like? Now that might be fine if you've been looking at data that's primarily concerned with non-disabled people, but what do you do with someone who's atypical? What do you do with someone who speaks slightly differently because they're neurodiverse? And this is really where AI models can fall down and would give rise to a different breach of the Equality Act, namely a failure to make reasonable adjustments.
Direct might be, not always, but might be easier to recognise than what you explained as indirect discrimination, where you apply a system and approach to everybody or to a grouping of people who have different characteristics. And it may not be clear whether or not that measure impacts disproportionately on a particular there's a difficulty, isn't there, also in working out whether the impact is justified by what it is you're trying to do. That's a debate that indirect discrimination throws up that doesn't apply with direct, which is much more straightforward. Is my reason for the treatment because of the protected characteristic?
Legally speaking, direct discrimination is much more straightforward, but one of the features of these AI models is that often the way in which they work is hidden within the black box. And one of the reasons that Jamie's example about Amazon is so useful is because actually we do know what was going on inside the black box. We can see that there was less favourable treatment of women. But most of the time, we won't know. So in that sense, direct and indirect discrimination are equally hard to demonstrate. So if we think, for example, about targeted advertising on social media platforms, these algorithms are not only very sophisticated, but social media platforms don't want us to know how they work because it's obviously protected by intellectual property rights. But what researchers can do is observe the outcome. And there's been lots of research to say that certain types of jobs, in particular STEM jobs, are often not shown to women. High-paid jobs often aren't shown to women. There's some terrifying research in the US showing that cleaning jobs are more likely to be shown to women or black people. So we can observe the outcome. Whether actually there's direct discrimination going on there or indirect is really difficult to know as an outsider.
I want to come back to the problem you raise about intellectual property rights and finding out how the system actually operates in a moment. But just still on the Equality Act, can we explain the public sector equality duties? So you explained what the lawyers might call substantive discrimination duties. There's a separate duty, isn't there, in the Act called the public sector equality duty. What does that do?
So the public sector equality duty only applies to organisations that are operating in the public sector, and it's what we call a procedural right. So it's an obligation on, for example, local authorities or police forces to have due regard to equality concerns. So they need to make sure they're thinking about equality issues before they've arisen. The idea being if we make these organisations think about it in advance, there's less likely to be discrimination further down the line.
I want to take a deep dive into one particular case called Bridges and the South Wales Police, which was a case in the Court of Appeal, brought by a civil liberties campaigner whose face had been captured on recognition technology being trialled by the police. It used surveillance cameras, CCTV, to capture images of members of the public, which it then compared with images of persons on what was called a watch list held by the police. So you could have been on that list if your presence at a particular event caused particular concern. And the software decided if there was a match. And in the case of a match, a police officer, in other words, a human being, would consider for themselves whether there was a match and might intervene, for example, by asking to stop to speak to the person and, if appropriate, using stop and search powers. The Court of Appeal said a couple of things. Firstly, they said the police hadn't undertaken a satisfactory impact of the data protection implications of the system because the assessment that they'd done had simply assumed that the use of the technology would accord with the human right to privacy, and it hadn't. But more interestingly, I think the court said that in using the technology, the police had breached the public sector equality duty. And that was because the police hadn't considered whether the software might indirectly discriminate against persons on the grounds of race and sex by generating more false matches in the case of black people and other people from ethnic minorities, and in the case of women, than in other cases. So it wasn't a decision that the software in fact discriminated on those bases, just that the police hadn't adequately considered whether it might. So this is a case about the PSED, but the PSED, Dee Masters, as you explained earlier, is about process. It doesn't itself prevent an authority from using AI. How useful really is the PSED in addressing the discrimination problems that we've been identifying?
It's not just a problem with public sector equality duty. The whole structure of the Equality Act is to focus on the end user of a particular technology. So here it was the police force. They were in the dock. They were the ones that had to show that this was non-discriminatory. Otherwise, they were going to be liable. But the problem with these AI models, whether it be facial recognition technology or any other system, is that there tends to be quite a complex value chain. And we see that in Bridges. It's not the police that developed the potentially discriminatory software. It's somebody else, maybe various actors, which are then placed in the hands of the police and then used. The public sector equality duty is useful in the sense that it requires organisations like the police to have due regard to discrimination. They might not be able to peer inside the black box, but they can audit the system, they can observe the outcome themselves. But that's really the end of it. And certainly from my experience, having seen equality impact assessments post-Bridges, I don't think organisations have really understood what the public sector equality duty requires of them. I don't see organisations actually doing a deep dive into how this technology works and satisfying themselves that there's no risk of discrimination.
Well, I mean, why would there? Whether you're a private or a public sector user of the technology, how realistic is it, I wonder, that you're going to want to delve into the development of the product that somebody is providing to you for the purpose of doing something? Well, the whole point of using the technology from your perspective is you're trying to make life easier. Perhaps you're trying to save time, perhaps you're trying to save money. It's a bit of a risk, isn't it, for those who would use these technologies in the state sector, given that the public sector equality duty applies to them. Aren't they taking a bit of a risk if they simply take the word, as it were, of the manufacturer of the product that everything's okay from a discrimination perspective and don't go off and look into the matter themselves?
I think it's a risk for public and private sector. And of course, what's really important to remember about the Equality Act is that there's no get out of jail card for saying, well, someone sold me this technology that was discriminatory. Liability fixes, whether it be under the public sector equality duty or more broadly under the Equality Act, on the person who deploys the technology. And ignorance is not a defence.
A particular problem, Jamie, it seems to me, with indirect discrimination, notwithstanding what Dee said earlier, that direct discrimination may also be hard to detect. But indirect, if you've got a hidden or not at all obvious impact, an impact on some protected group that might not be apparent even if you do sit down to turn your mind to the problem, you're at risk, even in the private sector, of being found to do something that constitutes substantive indirect discrimination and potentially having to pay someone some money as a result.
Indeed. And here's where we've got this weird legal gap between where we are and where we might be. It shouldn't really be a choice between, on the one hand, a tick box pro forma analysis, and on the other hand, simply taking producers at their word that what they've produced is compliant with the relevant legislation. In other areas of the law, we have advanced systems of certification, kite marks, objective standards, which you look at and you know, once it has been stamped on a particular product, whatever it is, a physical or intangible product, that it can be used for the purposes for which it has been certified. We haven't developed a legal framework as sophisticated as that in this country just now, and cases like Bridges show what happens when we fall between the gaps.
Bridges was also a case specifically about discrimination, at least in its main result. There was a point about the process that had been used to assess data impact. But if someone had come along, Dee, and run an argument that this was unfair processing under the data protection legislation, even if it wasn't discriminatory, that would have been an argument that would also have been able to be run in a case like that.
That's absolutely right. And I think so far, what we haven't really seen in litigation which looks at AI tools is a marrying together of the data protection legislation and the Equality Act. They often go hand in hand and typically should both be pleaded.
What about the problem of the limit? I mean, there are only so many protected characteristics, aren't there, in the legislation? Is this a problem in identifying impacts that people may think are discriminatory but may not be under the Equality Act itself?
Yeah, so Facebook patented a system which would allow you to assess whether someone was creditworthy, so how likely they were to repay a loan, by reference to the credit scores of the people who they were Facebook friends with. The theory being people who are friendlier with more people who pay back their loans are themselves more likely to pay back loans. Now, you might have views on that morally, one way or another. Why should my friend's creditworthiness have any impact on whether I can get a loan? But it's not immediately clear how that would fit into one of the categories identified by the Equality Act as being particularly important for protection. Now, listen, it's worth saying the protected characteristics are there for a reason. Sex, race, religion, these are characteristics that have traditionally involved structural disadvantages in society. But what's so interesting about machine learning systems is that they can create new disadvantages which legislators in the past might not have been able to think about.
When the Equality Act has limits, because, for example, you're concerned about an impact on someone who isn't protected because they don't have a protected characteristic, we also there have a second area of law, don't we, which is particularly important when thinking about AI, which is general data protection law. To what extent can the concepts in that legislation help to address some of the problems that we've been discussing where there isn't something that's discrimination properly so called?
In theory, quite a lot. Now, look, I don't want to send your listeners to sleep by describing the entire regimen of the UK data protection system, which is complicated and derived from EU law, which is even more complicated. But essentially, when you process people's personal data, that is to say, information relating to an identified or identifiable living person, you have to do it in a certain way. You have to do it lawfully, you have to do it fairly, and you have to do it in a transparent manner. What does it mean to say that it's lawful? Well, the act, the law, gives a number of gateways about how such processing can be lawful. A very well-known one is consent, for instance. If you consent to your data being used in a certain way, it is lawful. But there are others which are more vague, like legitimate interests, which some people would say are abused by people who process data in ways that we might find surprising or unreasonable. I have a little bit of a bugbear with the UK and the EU data protection system, which is that I think it rests too much on the idea of consent. I think it is, even with all the safeguards that are there, too easy for us to mindlessly consent away our permission to things. And I think that in some ways undermines a lot of the otherwise very robust protections that exist in the law.
I mean, the heart of the data protection regime, among all the other things that have to be thought about, is the idea of fairness, isn't it? You've got to process your data fairly. So if you're operating one of these machine learning algorithms, the way in which you use it has to be fair, including in its outcome. That's a pretty amorphous concept, isn't it? Is it a satisfactory one?
It is. It is one of those concepts that's been creating legal work for the likes of us for centuries, and no doubt will for centuries to come, because fairness is a protean concept. The guidance produced by the ICO says fairness means that you should only handle personal data in ways that people would reasonably expect, another concept that lawyers can go to town on, and not use it in ways that have unjustified adverse effects on them. Well, what's justified or unjustified isn't itself immediately always obvious. And then the ICO says you need to stop and think not just about how you can use personal data, but also about whether you should. I mean, this is one of those areas that lawyers and judges have had to do a lot of work in building the case law about what is and isn't on the right side of the line. And though we don't like to admit it, quite often it does come down to feel, to sense, to smell, the taste test. Does this feel right? Does it feel wrong? Even though we like to think it's more scientific than that.
Strikes me as a curiosity about the way the law fits together here, in the absence of any law specifically directed, at least at the moment in the UK, any law specifically directed at AI. You have this rather elaborate set of tests for discrimination, but you have this eye of the beholder type fairness test when it comes to data processing. One's a reasonably analytically heavy approach, and another might be thought to be more of a suck it and see. I wonder how satisfactory, Jamie, you think that situation currently is in the UK.
It's just a great example of how technologies throw up social problems that don't immediately match the legal categories that we've inherited from the past. And I just add this, it's not just that these are two very different bodies of law. People like Dee aside, there aren't actually that many lawyers who are expert in both of them. You will find lots of equalities lawyers who know their Equality Act back to front, and you'll find lots of data lawyers who are used to running data cases. But it's not necessarily a standard feature of lawyers in either of those areas that they should be absolutely familiar with the other.
If somebody was dismissed because an AI model deemed that they were no longer the ideal employee, you might have a data protection claim. You might have a discrimination claim if we thought the AI model was looking at your race or your sex. We might also have an unfair dismissal claim, which would look at reasonableness. So there are these really unusual circumstances where all these areas of law will overlap. But as Jamie says, structurally they're very different, and there are very few lawyers who are seeing how these different areas fit together.
All right, let's step back from the Bridges case and have a think about what we've covered. And I want to think about whether the law, or I suppose the enforcement mechanisms under the law, are adequate. I mean, on the law, first of all, the complexity, even when you can find out how the algorithm operates, the difficulty in proving that an algorithm has a discriminatory or unfair impact is not at all straightforward, is it? that's one of the reasons, is it, would you say, that we've had less litigation on this area, at least in this country, than you might have expected?
I think that's right. I think if you're going to litigate AI issues, there's a leap of faith to an element, because you're not going to know precisely how a particular algorithm is working or how you're being treated. Sometimes even the insiders don't understand how they work. But transparency is a double-edged sword, because it also means that if a claimant was brave enough to bring a claim against, say, a large tech company, the large tech company is probably going to have a difficulty explaining precisely how it's made decisions about those individuals too. And I think what we'll see in the future will be arguments about the burden of proof. It may well be that it's enough for a claimant to say, here is a system which cannot be explained, and that shifts the burden onto you as the tech company to explain that this is non-discriminatory.
And on the transparency question, there might be a difference, I suppose. Think about different legal regimes. There will be a different standard or set of rules that applies in the public sector from applies in the private sector. After all, there are particular mechanisms as applied to the public sector. I'm thinking about freedom of information. If you sue people, there's a thing called the duty of candour and judicial review that would apply to public authorities that won't apply in the same way to, for example, a private employer or a private bank. So you've got a bit of a patchwork quilt when it comes to the law enabling people to get transparency about these systems in the first place, which in turn makes litigating them more complicated.
You're right. And there are all sorts of initiatives out there trying to meet this problem. So you'll see, particularly in Europe, initiatives where people are invited to donate their data so that data can be centralised, so that we can reverse engineer how these algorithms are working. And I see huge potential for class actions, because one individual saying, I didn't see a job advert and I'm a woman, might not be very persuasive. But 500 women saying, I didn't see this job advert, starts to create a suggestion that something improper is going on.
I mean, that's right, Jamie Susskind, isn't it? Because if you're an individual claimant, campaign cases like Bridges aside, which are a bit difficult because they're trying to establish a general policy point or a public issue concern. But if you are an individual who's been concerned about the way in which your data has been used in a particular case, is the game really going to be worth the candle for you to sue? I mean, what are you actually going to get out of it?
No, and to a hammer, everything looks like a nail, and to a lawyer, everything looks like a claim for an individual. But actually, there are some kinds of laws that are better enforced not by individuals standing on their own rights, but as Dee says, by 500 individuals gathering together and standing on their rights, and or by a regulator or public body standing up for the rights of everyone in the society. And, on the transparency stuff, it seems to me to be wrong as a lawyer that in any situation, whether it's in an employment tribunal or in the administrative court, a defendant can win a case by virtue of their own lack of transparency. And whether that involves shifting the burden of proof or changing the standard of proof, whatever it is, it seems to me that it can't be an answer to an allegation of wrongdoing, that I can't prove myself whether I was right or wrong. And what the law should do is that it should rebalance things to make sure that defendants are the ones who have to explain themselves, and a failure to explain themselves shouldn't be able to put them in a better position.
There's been very little case law, decided cases in the courts, which have enabled others to see them as a precedent. But you've also got out there a series of regulators. Not just is it the ICO that Jamie mentioned earlier, who's responsible generally for policing the way in which data is used. You also have, as I understand it, sector-specific regulators who have a foot in the game when it comes to the use of AI. So, for example, the Financial Conduct Authority in the context of financial services, the specialist regulator of the police forces and the fire services. It's not very satisfactory to have all of these different regulators who might have different policy views on concepts like fairness themselves to be going off with their own powers individually.
It's enormously problematic. So the FCA is a vertical regulator, so they can set standards. We then have the Equality and Human Rights Commission, that's a horizontal regulator that has the remit for the Equality Act. How do they work together? How do they decide with an AI model that's about equality, data processing, and a financial services product, who's going to step in? I think it's incredibly important. If I go and buy a light bulb, I know it will have met certain safety criteria. There's no real equivalent when it comes to AI. So take, for example, facial recognition technology that we've been talking about. It's probably unrealistic to imagine it will be right 100% of the time. But how accurate does it have to be for us to be satisfied that it's an appropriate product? 70% of the time? 80% of the time? 90% of the time. And at the moment, industry insiders are deciding for themselves what is acceptable. But at some point, we're going to have standards that say a training data set needs to look like this, accuracy looks like that. It really is a headache, generally, for the government going forward.
Do we need a specialist regulator in AI, Jamie?
Well, worth saying that very recently the government white paper has indicated that that is not the course they are planning to take. To the extent that there's going to be centralisation, it's going to be much more to do with coordination than to do with creating a new regulator or regulatory body. My own hunch is that this approach will turn out to be inadequate.
If we don't have a specialist regulator for AI, are the courts themselves, judges who don't necessarily have any particular training or background in AI, particularly given how fast it moves, are the courts themselves suitably expert to grapple with not just the legal concepts that we've been outlining, but how those concepts apply in the very particular, potentially very complicated context of AI?
I think we're going to need capacity building for judges. These issues are going to come up more and more often in all sorts of contexts, and it's something that we need to be realistic about and make sure that we have a judiciary that can handle them when they appear.
When one takes a discrimination claim in a lot of contexts, you come across specialism in the judges, don't you? So, for example, in specialist contexts like employment tribunals, at least if you're bringing a discrimination claim rather than other types of claim, you'll have specialists, people, that is to say, who are experienced in the employment sector, one reason or another. They're a trade union background, a business background, and so on. If you sue on discrimination in the county court, the judge, who must be legally qualified, has to sit with assessors, as they're called, who are experts in discrimination law. That sort of thing's particularly important, isn't it, Jamie, when we come to this sort of stuff?
Yeah, and it shouldn't be controversial. We've had specialist tax tribunals for a long time. Why wouldn't we have specialist tech tribunals to deal with certain legal problems arising out of digital technology?
Dee Masters, Jamie Susskind, thank you for cross-examining with me today.
Thank you.
Thank you.
We've reached the end of the podcast, but we'll be back soon and we'd love to know what you'd like us to examine next. Tell us what you're interested in or concerned about in the world of law by tweeting at CrossExaminPod. Remember to follow us wherever you get your podcasts, and if you've got time, we'd love a positive review on Apple Podcasts. It's the best way to spread the word about cross-examination. Meanwhile, I've been Tom Cross, and until next time, goodbye.
Cross-Examination is written and presented by Tom Cross. The producer is Yelena Sofronievich.